Ms Bell, I've got a handful of questions from call participants. First of all, we heard evidence this morning that the SIBS, we looked at the terms of reference this afternoon to see that the SIBS advisory group's role is limited to having an input on operational and not policy matters. Is that right?
That's correct.
Who made that decision?
That decision would have been made when the group was originally formed up back in the pre-April 17 period. I would imagine signed off again, like the other criteria, by Scottish Government. The project team would have pulled it all together and drafted the documents, but it would all be signed off by Government.
Do you know whether there is a formal mechanism for the beneficiary community to provide their views about policy directly to the Scottish Government?
So I'm aware that the representative groups who are also represented on the advisory group have direct correspondence and discussions with Government, and it's clear from the discussions when we have the advisory group that they've talked outside of the advisory group, and they've obviously had direct conversations, but we have no role in facilitating that directly.
So does SIBS input into Scottish Government decision making about policy?
If we find we do have an input, and we, through our quarterly meetings, and occasionally, if required, in between those, we can feed into Samantha Baker's the lead of the team up at Government we tend to deal with, and we speak to her on a regular basis. I do know that one example before my time, but one example where the SIBS team spoke to the Scottish Government colleagues, there was a particular case which led to one of the two complaints we've had over the 3 years, and that complaint led to the Government changing policy. I think we touched on it earlier. It was around the cohabitee rather than civil partnership. I believe that's what that example was around. So that was fed in by SIBS as a potential problem. Government took it on, considered it through their own governance, and decided in that case to change policy.
So is this right, that through the advisory group, the beneficiaries' views about operational matters are filtered, are provided directly to the Government, but in relation to matters of policy, they can be provided to the Government by SIBS if SIBS is involved in discussing policy with the Government?
Yes.
But there isn't actually a formal mechanism in which SIBS is involved of giving the Government the beneficiary views on matters of policy?
Only through so the formal mechanism would be our feedback to the Government at our quarterly meetings. That would be the mechanism.
Can I just ask you some questions about something you've already given evidence on, but just to clarify your evidence? It's in relation to the widows applying to become members of the scheme. So in relation to a widow whose deceased partner is at hepatitis C stage 1, the requirement to who is not receiving and who before their death was not receiving annual payments from the scheme would need to make an application to become a member of the scheme themselves. Is that right?
That's my understanding.
Yeah, and we looked at the policy and what the widow or partner, widower, cohabitee, civil partner needs to show is that the hepatitis C directly contributed to their partner's death.
That's my understanding.
So if, for example, the partner died as a result of a road traffic accident, so unrelated to the infection, would what would SIBS do? Would they not accept the partner onto the scheme because they didn't meet the eligibility criteria?
I've never come across that decision, that situation. I think I would want to go back to the document and review the document to find out exactly what we can and can't do on that.
I don't know if it's helpful to pull it up now. Let me just find it for you. It's WITN 4508007. So I think it's the first paragraph there. If a person's husband, wife, was not entitled to annual payments at the time of their death and was a Scottish beneficiary, they're missing out the words in brackets, then they can still apply for an annual payment if they were married or in a civil partnership with the deceased beneficiary, were still living with them at the time of their death and have not since remarried. However, they will also need to be sufficient evidence that on the balance of probabilities, hepatitis C directly contributed to the spouse or civil partner's death.
Yeah, so the black and white answer to your question would be no, they wouldn't. But you would, what caused the road traffic accident? If they have conditions and fatigue and chronic fatigue, etc., due to their condition, did that contribute? These things are never as black and white. So I would want to try and understand the circumstances rather than before making a hard decision on that.
So SIBS would look widely at the question of direct contribution of the infection to the death.
Yes. Unfortunately, if there was absolutely no evidence of for any reason, if their condition was not a factor in the reason behind the accident, then the decision is probably no. But I think we'd want to look at that first rather than just taking it your hypothetical question as a black and white question. I don't think we would do that. We'd look further at it. And
then, in your evidence earlier, did I understand it correctly in this way, that if there is evidence of a direct contribution, that the hepatitis C made a direct contribution to the member's death, SIBS would be looking at the clinical information that would be given both on the death certificate and from the clinician who's providing evidence, to look at what level of payment, what level of annual payment the widow should receive, because it may be that there's sufficient information to show that in fact the deceased member was at stage 2, albeit not receiving stage 2 payments, and so that would impact on what the widower partner could receive. Is that right?
That's correct. That's why we do the more detailed investigation.
I asked you some questions about those applicants who apply to the scheme and don't have medical records that evidence the treatment that they allege caused them their infection, typically hepatitis C. Are you able to tell us what proportion of those applications are successful? So no evidence of transfusion in the records.
Not off the top of my head. I'd have to look at the detail.
And is that data that is captured by SIBS, so is easily obtained, or would it be a question of going back and looking at all of the applications?
Yeah, we'd go back into all the applications and look at the detail.
And just a bit of detail on how such applications are assessed. We looked at the guidance and we looked at the 5 criteria whereby SIBS assesses whether or not the lack of supporting evidence is fatal to the application. How is evidence in the form of witness statements treated on such an application? How do you establish the general credibility of an applicant on a paper application?
So we take the applicant's statement. Obviously, if there's no evidence at all, medical evidence at all, then we seek advice, as we've already explained, from Professor Hayes as to the probability of something. So to take your example about a road traffic accident, and if someone had received surgery after such an event, then you might expect a potential transfusion or a blood product of some sort might have been used. So it then comes down to the detail of the statement, and we may have to follow up and go back to the applicant and ask for a bit more detail to make sure that if the detail in the statement comes across as credible, and that the clinical advice is that procedure would likely or probably require or use blood product of some sort, then obviously we can then make the award. So it comes back to we may have to go back to the applicant and ask for more detail, and in the event of not being successful, of course, there's an independent appeals process that we would then advise them about, and that they can also have other witness statements to as well. And I know the appeals panel has heard different verbal witnesses of what was seen, which would give the panel maybe more detail than we were getting on a written statement, which just builds the picture to make it a bit more credible. And that's certainly, I think, been the case without going into specific details.
If the advice from Professor Hayes is it's not clinically plausible that this procedure would have required a blood transfusion, is that the end of the application? Is that fatal to the application, or do you still go on to look at the credibility of the information being given by the applicant?
I've certainly had one case where I have made a decision to end the application at that process once it had come back as being improbable that a transfusion or blood product of any sort would have been required for the injury sustained and the subsequent treatment that injury required. That in the absence of any other evidence and the clinical input, that's one case at least I can remember saying no and not accepting.
But is this right? It's not necessarily fatal to the application, but it would be very difficult for it to survive both the absence of medical records and clinical implausibility from Professor Hayes.
Yes, that's correct.
What information do you seek in cases where, in cases of doubt about local transfusion practice at the material time? So, for example, would you seek information or evidence about a general policy in a particular hospital or area in which the applicant says that they receive their treatment?
I guess that would go. We do routinely ask Scottish National Blood Transfusion Service, who provide all the hospitals with the blood product. We would routinely ask them for any evidence that they might have, both of a direct transfusion, because often they might have records that hospitals may have already removed, but also they would then be in a position to give us any specifics about regional variation, if indeed there was any regional variation at the time.
And can you recall getting such information or evidence from the Scottish National Blood Transfusion Service?
I don't recall anything around regional variation at all.
Or particular policies in hospitals?
No.
Or transfusion practice over a particular period?
No, certainly not in my 2 years. That's not come across my desk, as far as I can recall.
Those were the questions, sir, that I was going to ask from call participants.
Yes, thank you. Just a couple of small questions. First of all, picking up a question which Ms. Scott was asking a moment or two ago, appeals from a refusal by the scheme to accept a beneficiary. Have you any sense as to what proportion of the refusals which are appealed successfully?
So Brian, I couldn't give the exact number, but I would feel it's less than 50%. But I could get the exact numbers. I thought we had provided that in the evidence statement.
You may well have done. It's something which I haven't had time to check, so I thought I'd ask you off the top. But roughly, roughly, you think it's less than half.
Less than half, sir. Yes.
Thank you. The other question is very much a point of little detail, and you just may be able to assist me as to how the scheme works. We looked at earlier at the definition of dependent, which was a child under 21 or under, and in full-time education. In Scotland, certainly it used to be the case that many would-be students left school at the age of 18 in order to go to university, which was then generally a 4-year course. Is that still the case?
It is, Sir Brian.
So, in the usual case, if this is the usual case in Scotland, somebody would be over 21, probably, 18 when they leave school, 22 when they leave university, if they've gone straight into university without any gap in between. How would they be funded, if at all, during the last year of their university career? Would they simply not get anything, or would that be a case for discretionary grant, and if so, on what basis?
I think that would be, I would want to have a discussion with government colleagues to see what latitude there is in the definition within the scheme document, and whether, because they remain as a 22-year-old potentially still in full-time education, whether that would allow us to make the payment. So that's a conversation I would want to have with Samantha Baker up in government to clarify what flexibility I would have in the scheme document.
It probably follows from your answer, but you may be able to confirm it, that it hasn't yet occurred.
That's certainly not in my 2 years, sir, no.
Well, thank you very much for that. That's all that I have to ask.
So, Mr. Bell, in your witness statement, you say there have been 9 appeals, and you provide information in relation to 8 of them, 3 successful and 5 unsuccessful. Does that sound right?
That sounds correct.
Mr. Bell, is there anything you wish to add to your evidence?
I think, if I may, Ms. Scott and Sir Brian, I'd like to take the opportunity publicly to thank my team and the SIBS team. It's a small team, but they care and they do an awful lot, and I think it's worthy of a thank you publicly. I'd also like to thank the advisory group and our members for all the feedback and advice and guidance we get from them, whether that's through the routine meetings or indeed through our surveys, because all of that input gives us a better picture in order to help us improve and despite the fact that we have got some good results in our surveys, there's definitely room for improvement. And I guess my final point would be to thank thank you for the opportunity of giving evidence, because going through this process from sort of late last summer and building my original statement and up and including today, I guess it's been really good for me to I guess a bit of a deep dive in a lot of areas that don't routinely come across my desk, and so having the opportunity to go through that has helped, and we've definitely identified areas for improvement through that journey. So it's really it's to thank those involved, and to commit that we continue to try to improve as we go forward. I think that's all I wanted to say. Thank you.
It's very generous of you to thank us when it is for us to thank you for coming to give your evidence. It has helped me certainly to understand more about the way in which SIBS works, to have an insight into you as director and what you say about your team, and to be reassured by the sense that you've given of looking continuously for ways to improve what you can do. I'm sorry that we've detained you for longer than we might have done. You started a bit late for reasons which were unavoidable. We've detained you, I hope not too late from getting back home from Gyle.
All good.
But we've also left you with some homework to do, I think. You've offered on a number of occasions to fill in with some further information. I for one, am looking forward to the animated version of that you promised to send, and which I have a sense I might enjoy watching and understanding what people see. So thank you for that. And thank you for being here remotely as it is. And good evening to you. Now, Miss Scott, tomorrow.
Yes, tomorrow we have witnesses from Northern Ireland, so we begin with the Minister and followed by evidence from...
That's Mr. Swan.
Yes, Mr. Swan, that's right, followed by evidence from Ms. Redmond.
Yes, well, 10 o'clock tomorrow in that case. Thank you very much. 10 o'clock tomorrow.